Hello, everyone. Welcome to Court with Krissy. This defendant was blessed by Judge Wiggins. He got a week of freedom. And yeah, he messed that up. If it's a millennial thing, I obviously don't understand. I hope you like it. Court with Krissy is now in session.
These are case numbers 26858SM and 25544SM. Appearances, counsel.
And I'm Jeff Pierce. I'm here on behalf of Mr. Freeze. He's next to me at the table.
Counsel, we are here in 25544 for a probation violation sentence and for a sentencing in 26858. We set 858 over for victim notification. Is there any victim input?
No, Your Honor.
Allocution, then, Mr. Harrison.
Well, I think it's easy to look at this. It would be easy to look at both of these situations in the extreme, okay? We've all read the recommendation from the probation department with regard to the PV file. It would then be easy to, and I'm not trying to load the term, but I'll use it anyway, overreact to the basis of the probation violation itself, this incident with Deputy. I think what it shows us is that this is a guy who's scrambling. He's scrambling financially. He's scrambling to keep what little he has to his name right now. He is able to work. As you can see, he came from work today. And that is putting a lot of pressure on his interpersonal relationships, as it would anyone, quite frankly. He and Deputy don't live in the same apartment. They do live in separate units there, but they spend a lot of time together. And this incident arose over a stupid argument over a cheeseburger. And as he indicated to the court when his plea was sent or presented to the court, he lost his temper and threw a pan against the wall and broke a window, and some other things happened. I took great note of that because he didn't do that gleefully. He didn't say, "Oh yeah, Your Honor, it was crazy. I took this pan." But he was matter of fact in his presentation to the court. Let's talk about that isolated from the PV. Now, the PV indicates a long history, at least the recommendation does, of non-compliance on the part of Mr. Freeze. That's one way to look at it, of course. I don't disagree with her factual presentation. For example, he either took the class or he didn't. In this case, he didn't. He didn't take the anger management class. It wasn't offered. It was offered only on a Thursday, and he found out that he had work on the same Thursday, et cetera, et cetera. It's easy for us, I think, as we sit in the courtroom to say, well, get your priorities in order. Go to that class when it's available. Don't go to work instead. That's really hard to say to a guy who does not have stable employment. He's working toward that. But right now he works, well, I guess as needed would be the way to say it. So when he's needed, he goes to work and works hard and earns money. So he's reluctant to turn any of those opportunities down. Now, he and I have talked about it in the interim, and I think he now understands sort of where the probation department and the court, to a certain extent, and the prosecutor are coming from, that there aren't really any good excuses to shirk your responsibilities while you're on probation. Probation is a privilege because it stands in lieu of being incarcerated in a jail or a prison. I don't know if that had really sunk in to the extent that he understands that now. And I spoke to him in pretty blunt language, just like I said to the court. I guess it would be easy, and again, I'm not trying to create any drama here, to look at this in the abstract and say, yeah, okay, he violated his probation, and at the same time he committed a new criminal act. That overcomes the presumption. That overcomes the idea that he's simply not supervisable, if you will, on probation because of his failure or lack of attention, as I would say it, to his obligations under this current term of probation. I, of course, would encourage a slightly different and slightly more nuanced view of the situation. What I would say to the court is, look, here's a guy who lost his temper, and he knows he shouldn't have, and he knows there's a way for him not to have that reaction in the future. it's a circular argument because the way he knows how to deal with that is to take the anger management class that he was already supposed to be taking. It's easy for these obligations to stack up on you, particularly when you are scrambling to keep a roof over your head and a few bucks in your pocket. Thank you.
Thank you. Ms. Dahl?
Mayor, I ask the court to follow the recommendation in the case 25544 SM with regards to case 26858 SM. I would ask the court to not place the defendant on probation in any time imposed to be concurrent with the probation violation case. Seems like he's not a good candidate for probation. He's not been successful so far in case 25544 SM. He's been given opportunities. He's not taking advantage of it. So that's the proposed request.
Thank you. Mr. Freeze, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Yes, Your Honor. It's been a lot of years since I've been in trouble. When I was a juvenile, I was reckless, and then as a young adult, I just didn't even try. And then, it's been almost 8 years since I've had any serious traffic offenses. I've been actually trying to be a good role model for my son. My son's 18 and graduated now. And to focus on one thing at a time, like maintaining employment or maintaining a full belly or maintaining a spot to be able to sleep. Those are not three consistent things that I find in a day. But my Uncle Mel, he's offered me a chance to just show up, help him check the pressure and tires for the FedEx semis. He maintains their entire delivery fleet or whatnot. So he's able to drive by and pick me up and let me come and work for an hour or two and have $20, $30 in my pocket so that I'm not out committing new crimes to try and get a snack at night or a soda or whatever. And I really have not been paying attention to the anger management classes because each one of them are at 10 to 11:30, and that's if I get up at 9 and meet my uncle at the shop, that takes us a few minutes to get tools out and whatnot and get started. Before you know it, it's noon. And it's just, I understand that I've lost focus, but I didn't mean to commit a domestic or to instill fear in this person. I exploded. I threw the frying pan across the living room and I left to go to work and left the situation. Unfortunately, I caused damage to the property, causing us to be asked to leave. And so for the last week, I've been packing up and sleeping at my uncle's shop. I was given a week out, and you said last week that what I do in this time was going to affect your decision. And Debbie has not been a part of my life at all. I haven't even seen her and spoke to her, and I haven't even had a chance to be at my own spot. So I just want the court to know that I've respected the no contact order and done things to try and keep moving forward.
Well, if I recall correctly, you were, and you just said it again, that you were working for your uncle kind of as an on-needed basis, so not full-time, but as needed. So why, I could understand if you were working, I shouldn't say I understand. I can at least buy the excuse that if you were working full-time, you couldn't make time for the anger management classes, but where you weren't working full-time, what is your excuse for that?
Daylight hours, sir. They're just prime time to be functioning and staying consistent. And I really don't, there's no excuse, Your Honor. I can't.
So I know you had some history in the past with some controlled substances. Are you clean from those now?
Yes, sir.
If I were to test you today, would you test clean? Let's go ahead and do that. Can we take him down to community corrections and have him tested? All right, we're kind of, will counsel approach, please? All right, we'll go back on the record then in Jacob Freeze's case numbers 25544 SM and 26858 SM. Parents' counsel.
I'm Jeff Pearson. I'm here on behalf Mr. Freeze, he's joined me at the table.
Also, I have received results from Community Corrections. Mr. Freeze is testing positive for amphetamines and methamphetamine. It's also reported that he attempted to falsify a urine test with toilet water. He admitted to using meth the day he got out of jail. All right. I realize those aren't necessarily bond. Well, let me double check something here.
Formal testing required to reinvent a standard term.
Yeah, there was not, other than he not break the law. So, Mr. Harrison, do you want to change anything regarding your elocution?
Well, obviously, I would put an addendum onto my prior comments, okay? I think I don't know why this is, Your Honor, but this does seem to be something that we've seen, that meth is so prevalent and so available that it's viewed by some people as a celebration type situation, like where my generation might go drink a six-pack. I think it's replaced that in some people's, at least in their worldview. Obviously, it's far more dangerous than that, but that is what appears to be the case here, that he was released from jail, wanted to blow off some steam. I wish he had, and he wishes he had, quite obviously, picked a more constructive way to do that. Again, I think we need to take all of this in context, and here's what I mean by that. If we were to look at this on a continuum and say, oh, look, this guy's made almost no progress at all. He's crawled through probation and not observed any of his responsibilities. But if we look at where Mr. Freeze started from, at least in his view of the world and in his headspace, he's made remarkable progress to the extent that he's able to do things like admit responsibility for the use of a highly addictive, highly illegal substance. I, for one, think that's laudable, at least in this case, that he's like, okay, you got me, I used. And I don't think anyone needs to belabor that point. It is what it is. I would simply have the court apply that against the backdrop of my other and prior remarks. Thank you.
Thank you. Ms. Dahl, anything else?
Your Honor, I just remain with my request is that the recommendation is followed in the probation violation case, and that any time he gets in the domestic violence case run concurrent, I don't believe he's a good candidate for probation in the direct case.
Thank you. Ms. Bismack, a question for you. I'm looking at the recommendation and I see it says 60 days jail, 5 days credit total on the case, and 2 day credit for total on the PV. Is that right?
7.
7 on the PV?
65 and 7, right?
All right.
Okay.
So 10 total and 7.
All right, Mr. Freeze, I know we did this once, but I'm going to circle back to you again now that we have some additional information. Is there anything that you want me to know?
Your Honor, when I got out of jail, I was blessed by you. And I got home to a very volatile situation. I was all alone. I destroyed all my drug paraphernalia. I threw it in the wood stove, got into an argument with my landlord, Don, and he asked me to not stay there. And for the next 3 nights, it was a blizzard. I've been out on the street. Doesn't make anything acceptable. It was just the company of the people that I sought shelter with. I was partying it up, not like drinking and being crazy out, smashing stuff or being violent. We're just they asked if I wanted to indulge, and I hit the point a couple times. I'm not saying that I smoked a marijuana cigarette that might have been laced or trying to play it off. Your Honor, I made a poor choice. That's all.
So are you saying that I don't want to say sticking with the story, but I guess I'll say that. Are you sticking with the story that you only used the day you got out of jail? That was the 18th of March. We're now at the 20th.
Well, it was at least the 20th. I'm not saying like I used this morning or came in here.
And I'm being told that this was I missed that, this was an oral test, not a urine test. So it was an oral swab.
Your Honor, if I correct that, no, it was a urine. They were prepping for an oral.
Oh, she sent me oral.
Well, it's marked oral, so that's why.
Okay.
I'm glad we had the clarification. I apologize.
Okay. Yeah, and the picture is an oral test result. Well, Mr. Freeze, as I had said when I released you, how you behaved between your release and today was going to tell the court a lot. And it did tell the court a lot. In the probation violation file, case number 25544 SM, the recommendation in that case is for 60 days jail to an underlying offense of disturbing the peace, so a 90-day jail sentence. Credit for the 7 days. I'm going to terminate probation unsuccessfully. Court is going to follow that recommendation in part. This is based on new criminal behavior of domestic violence, so the court is not bound by the 5 days progressive steps that we're used to for technical violations. So I am going to revoke probation. Sentence in that case will be 45 days jail. Credit for 7 days. Fines and costs reserved.
I understand that I'm not able to get work release because I have too many housing debts with the jail, but like any way that I can keep my job.
Mr. Freeze, I gave you that opportunity when I let you out last week, and you paid me back by using methamphetamine in between time. In case number 26858 SM, this is the domestic violence case. I realize that at least as reported to the court, this was not the most egregious domestic violence, although it was reported that a frying pan was thrown in her direction, and that certainly would have caused somebody to fear an immediate battery. The defendant has shown he's not a good candidate for probation. He's also shown that during the time that he was released on this, that he also used controlled substances as well. He pled to a 93-day misdemeanor. His criminal history, can I see that file back?
Yeah.
Thanks. His criminal history consists of the disturbing the peace that we just sentenced to for the probation violation, an MIP in 08, retail fraud 3rd, and possession of marijuana and use of marijuana from 12, possession of marijuana in 13, receiving, concealing 200 to 1,000, 2 counts of that, domestic violence, possession of marijuana. In 14, there was a B&E with intent, larceny from a vehicle, malicious destruction of property, 200 to 1,000. 15, use of a controlled substance, and 18, use of marijuana. This, for all intent and purposes, is the defendant's second domestic violence, even though it wasn't charged as such. So the court does believe that a jail sentence is appropriate there. The court is going to do 60 days jail. Credit for 6. There is a $75 crime victim rights fund fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fee. The defendant is entitled to $30 back towards his fines for being incarcerated for 6 days. Mr. Freeze, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. You have the right to appeal this decision because I have sentenced you to a period of incarceration. You decided that you wanted to appeal and could not afford an attorney to assist you. You have 14 days from today's date to request the appointment of an attorney. You can go with the corrections with the bailiff.
60 speeding.